please, Registrar, administer the oath of affirmation.
Please state your full names for the record.
Clinton Martin Ephron.
Do you have any objection to taking the prescribed oath?
No.
Do you consider the oath binding on your conscience?
Yes, I do.
Do you solemnly swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. Yes, Mr. Slega.
Thank you, Chairperson. Mr. Ephron has been called to come back to testify before the Commission. He's done so previously, but he's called back as a result of allegations recently, or versions recently advanced before the Commission, particularly in regard to what took place prior to Glencore acquiring OCM, Optimum Mine, and thereafter invoking the hardship clause, which is found in the coal supply agreement between Eskom and OCM at the time. There are certain versions of particularly Mr. Koko and Mr. Ran Malefe, which we wish to put to Mr. Clinton Ephron in order for him to clarify to the chairperson the position in regard to Glencore and OCM at the time.
Yes. Okay.
There is a file, chairperson, which we will be using for Mr. Ephron's statements, which I believe he will now confirm under oath. The bundle is, or his statements are found in Exhibit U5, capital A. Mr. Ephron, on your side, you would have been sent an electronic copy of this bundle. You confirm having it?
Yes, I have it.
Thank you.
I do. I have it.
Thank you. Your first statement is found on page 1 of that bundle.
Correct.
And it runs up to page 28. Up to page 28.
Yes, that's correct.
That's correct. Above the name Clinton Martin Ephron, there's a signature there. Do you confirm that to be your signature?
I do.
And I know you would have confirmed the contents of your statement in your first appearance. But just to complete the picture, you do confirm the correctness of the statement, the contents of your statement.
Yes, I do.
Chairperson, we could have this admitted as an exhibit.
Well, I don't know whether we should do that.
We should do that.
Because things were done in a certain way at the beginning.
In the beginning, okay.
You know, the file was marked as an exhibit as opposed to
I'm sure.
the actual statements.
Correct.
And maybe we should not cause any confusion.
Yes.
But obviously the statement has been admitted, and it's just that it wasn't marked as an exhibit on its own.
Yes.
So maybe we should just live with the past the way it is.
There's just two more of his statements.
Yeah, I think probably just have to refer to them as the statement of such and such a date and the statement of such and such a date. We shouldn't have had the file as an exhibit. We should have had the file as a bundle.
Correct.
And then the statements inside the file as exhibits.
As exhibits.
Yeah.
Yes.
So the statements, even if it might not have been expressly said, they have been admitted. They, or maybe by implication, it's just that they are not marked as exhibits. Yeah. Okay.
Thank you, Chair.
Yeah.
Mr. Ephron, let's do the same with your last two statements. The second is found on page 322.
Yes, that's correct. Except as you'll note on the third statement, we corrected something in the second statement.
Correct. So the second statement starts on page 322. It ends on page 326.
Correct.
The statement is dated 11 February 2021. See that?
I do.
And there's a signature there above the name Clinton Martin Ephron. Do you confirm that to be your signature?
Yes, I do.
Do you also confirm the correctness of the contents of the statement?
Yes. Save as to the error that was made and that was corrected in statement 3.
Okay, talking of statement 3, that is found on page 327.
That's correct.
The statement is dated 14 April 2021. See that?
I do.
It's a one-page statement. You confirm?
Correct.
You confirm the signature there to be yours?
Yes, I do.
And you confirm the correctness of the contents of the statement?
Yes, I do.
Thank you, Chair. The statements will also be, or we beg leave that they be admitted as part of this Exhibit 5, capital A, Chairperson. Shall we proceed, Chair? Shall we proceed, Chair?
I'm sorry, I had not seen this
Oh, it's the two statements.
the statement at 327 on. I may have seen it, not read it, so I was just quickly having a look at it.
Yes. Mr. Ephron will explain it as well.
Okay, I've just done so.
Yes.
Okay, so you have dealt with all three of them.
Yes, Chair. Thank you. Yes.
Okay. Maybe I could just ask this question, and maybe it is a question you are going to start with. Mr. Ephron, is there a particular reason why your statements were not under oath? This was raised by both Mr. Brian Molefe and Mr. Koko, who said that they were required to submit statements under oath, and they submitted statements under oath, that is affidavits, but Mr. Ephron kept on just sending statements that were not under oath. Was there a particular reason?
Mr. Chairperson, no, there was no particular reason. We were just asked to submit a statement.
Yes.
But I'm happy to now confirm that they are. I'm happy to now confirm that they are under oath.
Yeah. Okay. All right. Mr. Selega.
Thank you, Chair. Mr. Ephron, just by way for a brief background. On the facts before us, there are three entities. There's Glencore, Optimum Coal Holdings, and Optimum Coal Mine, Pty Ltd. Could you explain to us what your position was in relation to the three entities?
Sure. So I was employed by Glencore in South Africa, and Glencore purchased approximately 67% of OCH, and OCH in turn held 100% of the shares of OCM. So OCM was a wholly owned subsidiary of OCH, and my position at OCH was I was a director and effective CEO of OCH.
Yeah. And OCH was a South African-based company.
Yes. Yes, that's correct. OCH, South African-based, initially listed and then unlisted. Public and then private.
So, you said you were effectively the CEO of OCH. You say effectively, that suggests to me that you may not have been appointed as such on paper, but in terms of what you did, practically you played the role of a CEO.
No,
Correct?
I was appointed as CEO. Mr. Chairperson, I'll correct that. I was appointed as CEO.
So you were the CEO of OCH.
That's correct.
Yeah. And at Glencore, because you started by saying you were employed by Glencore, what was your position in Glencore?
So in Glencore, I was the head of coal trading and coal operations in South Africa.
Okay.
And I was also a director on the local Glencore South African subsidiary.
Okay. And in OCM, did you have a position or not?
Yes, well, effectively I would have been, this is why I used the word effective previously, is effectively I would have been the CEO of OCM as well, being the CEO of OCH as the holding company. So all the companies that were underneath the umbrella of OCH, which is Optimum Coal Holdings, I was the CEO of all the companies.
You have gone back to using effectively. With my earlier question, then
I use effective because Mr. Chairperson, I'm not 100% certain that for every underlying wholly owned subsidiary I was appointed as CEO.
Okay.
I'd have to check that.
Okay.
So if we could certainly check that, but there were a number of subsidiaries under OCH, and I'm not entirely sure whether I was appointed CEO of each individual wholly owned subsidiary of OCH, of which there were a number of them.
Yeah, of course, our interest is more on Glencore, OCH, and OCM, but you say in regard to OCM, you are not sure whether you were appointed CEO, but at a practical level, you played the role of CEO. Is that correct?
That's 100% correct.
Okay, all right.
Thank you,
Mr. Slayer.
Mr. Ephron, are you able to see us here in the hearing room?
I can see you both when you're speaking, yes.
Okay. Thank you.
Thank you.
So we've gone through your statement, the first statement, in which you set out the details about how Glencore came to purchase or acquire OCM. And the time period within which that transaction took place. So is it correct that this took place in the period between June 2011 and March 2012?
Yes.
Just tell us, or just relate to the chairperson, the entity that Glencore was actually acquiring. Was it OCH or was it OCM, or both of them?
Well, it was OCH, and to reiterate, OCH owned 100% of the shares of OCM. So buying the shares of OCH, you would effectively own the shares of OCM. OCH was just a holding company with subsidiaries in it.
In that period, June 2011 to March 2012, were you the CEO? I mean, an employee of Glencore?
Yes.
And director in Glencore?
Yes. Glencore's local subsidiary, yes.
So at the time of the acquisition, well, you can tell the chairperson whether or not this is correct. At the time of acquisition of OCH, you became the CEO and director in OCH?
Yes.
So from the time of acquisition?
Yes, once the deal was effective and closed, then I got appointed as CEO and director.
So the following aspect or facts will fall within your knowledge as to the reasons why Glencore did not do a due diligence when it acquired OCH?
Yes.
Can you explain to the chairperson what the reason was for Glencore not conducting a due diligence?
So, Advocate Seleki, if I may correct you, we did not do a due diligence. We did a reasonably extensive due diligence, and I can point you to my paragraph 14. I'm just going to see exactly where it is on my initial statement. I'm just going to
it is
find
paragraph
the
14
page.
of page 3. It is paragraph 14 of page 3 in this bundle, where you start talking about a
Correct.
comprehensive due diligence.
Correct. Correct. So just to give you some history here, we specifically mentioned that we did not do a comprehensive due diligence, but it's worth noting the following. OCH was a listed company and had listed 1 year prior to the commencement of the Glencore group of companies starting to acquire the shares in OCH, which meant the following. This is very important. In order to list on the Johannesburg Stock Exchange, OCH at the time would have had to put out a pre-listing statement, and they did so. And it was a 300-page statement, which included a recent competent persons report, a recent independent technical report, and an independent competent persons report of the material assets of OCH by a company called SRK, which is an independent company. So all this information, together with the information that Glencore had through its knowledge of the industry, would have allowed us to prepare a due diligence and to perform a due diligence which was sufficient under the circumstances and associated with the risk that we were prepared to take. And I'll explain that a little bit later, because I'm sure that's a question that's going to be asked is why was it not done? But the reason why, and I'll get there, but for now, one needs to understand that there was a significant amount of information that was available to us in order for us to run models and do a very good assessment of the value of this company.
Yeah, were you reading from somewhere? Finishing the...
No, I wasn't reading. I wasn't reading from anywhere,
yeah.
but I was not reading from anywhere, but I do recall the facts at the time that we used the word non-comprehensive because we could not go in and kick the tires of every single vehicle or every single borehole in the ground, but we had sufficient information in order to give us a very reasonable understanding of the company and its value there too.
Yeah, I see that in that paragraph 14 of your first statement, on page 3.
Mm-hmm.
You do say that Glencore was not able to undertake a comprehensive due diligence exercise. In particular, Glencore only had publicly available information regarding the CSA, and it only knew the duration, volume to be supplied, and price per tonnage provided by the CSA. Glencore did not, for example, know how any price adjustment mechanisms in the CSA worked. Now let's see whether you could answer this allegation that Glencore would have failed to do a comprehensive due diligence, as you state in your statement, because Glencore had a connection with the current president, Mr. Ramaphosa, and that Glencore intended to leverage his influence in order to negotiate a price increase with Eskom once the acquisition of OCH had taken place. What would be your comment to that?
I think that allegation is preposterous, and I can't understand how and why someone would think such a thing. The reason why we did not do a comprehensive due diligence is the following. I'd like to point you to my second statement. We're going to have to go to page
It's page 322 on the hard copy.
Thank you very much. Page 322 and paragraph 6. 323.
Yes, on the soft copy. Thank you. That's good.
Correct. So let's just go back one step. Why did we not do a comprehensive due diligence? This is not an uncommon strategy when procuring a company. One has to assess the risks associated with not doing a comprehensive.
I'm sorry, Mr. Ephron. You said 323. Is there a particular paragraph that you want me to look at as you give evidence?
Paragraph 6.
Okay, all right. Continue.
So there are two mechanisms in terms of buying a listed company. There are two ways in which one can do it. One can approach the company directly and attempt to buy the shares from the company once they approach the end of their shareholders, or you can approach the shareholders directly and through a series of private transactions, obviously through the market, you would be able to secure a certain amount of shareholding in the company. So the reason why we did not approach OCH directly was because had we done so, OCH would have had to put out a public notice, a SENS announcement that its share price could be affected as a result of a certain transaction. So we said, in order to ensure that the price remained competitive, and we knew that there was potentially a competitive process out there, a number of prospective buyers were interested, we elected to approach individual shareholders directly. So as a result, we could not enter into a non-disclosure agreement and go ahead with a company and kick every tire. We felt that we had sufficient information, sufficient knowledge about the company through our industry knowledge, and in addition, the pre-listing statement, which I previously mentioned, which was 300 pages long, gave us substantial amounts of information around the company. So we did not kick the tires. We did not know every single asset within this company, but we certainly had a pretty good understanding. In going to your question, Mr. Selecki, there is not an iota of evidence that points to the fact that Glencore in any way wanted to rely on the relationship with Mr. Ramaphosa as our shareholder in order to change the contract price. It's ridiculous. We can show, I mean, the commission has interviewed a number of Eskom directors, a number of Eskom employees, past and present, and nowhere has it ever come up that Mr. Ramaphosa was involved in any discussion or negotiation around the CSA of OCM. I go one step further. In paragraph 9 on page 324, I'd like to please read it out. Yes, I never asked Mr. Ramaphosa to intervene on behalf of OCH or OCM in any matters relating to Eskom or the CSA, and to the best of my knowledge and recollection, he never did so. So we strongly deny this allegation.
Yes. Were you personally involved and directly with Eskom in regard to the coal supply agreement?
Yes, every step of the way.
Yeah. Now, the acquisition was completed in March 2012, you say in your statement, which you have now confirmed under oath. And you do say that, I think it's around July 2013, OCM decided to invoke a hardship clause. That's a little over a year later.
Maybe before you go that far, Mr. Seleka, Mr. Ephron, is it in 2011 or early 2012 that OCH acquired OCM?
Mr. Chairperson, it was a series of transactions. So there were a number of transactions that we entered into.
Yes.
Between June 2011 and March 2012.
Yes. So the point at which you could say, it could be said that the acquisition of OCM by OCH was complete, would it have been in March 2012, in your view?
So just to correct you, Mr. Chairperson, it was not the acquisition of OCM of OCH, it was the acquisition by Glencore, Lexshell, and its other shareholders that finalized the purchases of OCH by March 2012, correct?
Yes, but as I understood the position, I thought earlier on you said Glencore acquired OCH. Or is the position that OCH,
yes, that's what,
OCH already held 100% of shares in OCM before Glencore approached.
Yes,
Oh, okay, all right. So OCH,
yes, Mr. Chairperson.
OCH was
Yes,
at all material times in control of OCM, and then Glencore just
That's
acquired
correct.
the shares. Is that right?
Of OCH.
Of OCH.
That's
yeah.
correct.
Okay, no. But the point in time when it could be said, or rather, let me say, what is the point in time when Glencore had acquired OCH, the shares in OCH?
I think you're referring to at what time Glencore and its partners had control of OCH.
Yes, that's what I'm talking about. Yeah, had control of
That would have been in and around March 2012.
Okay, all right. Do you know what Mr. Ramaphosa's position was in that regard, whether in government or in the ruling party?
At that point in time, my recollection was that he was not involved in government.
Yes. And then in the party, was he already deputy president?
He
or what?
only, no, he only, my recollection, and I really do not have the exact dates, but when Mr. Ramaphosa divested his interest in all his mining ventures, this one included, was in paragraph 13 of my first statement. And that is on the 22nd of May 2014. So it would have come after that. Mr. Ramaphosa would have become deputy president only after that date.
That is deputy president of the country. But what about deputy president of the party?
That's correct.
What about the deputy president of the party? Can you recall when he became that?
My recollection is that he was not involved at all in politics prior to his taking up of deputy presidency of the country. But
yeah,
I'm sure these facts would be able to be easily verified.
I think the information in the public domain would be that he was elected deputy president of the party at the Mangaung conference in December 2012, Mangaung conference of the ruling party in 2012. I think that's my recollection, just from the public domain. Does that sound right with you, or you don't know?
I really can't confirm that.
Yes.
I seem to recall that when Mr. Ramaphosa was going to take up the position of deputy president of the country, he divested himself of all his mining and, in fact, all his business interests in South Africa. So that's what I seem to recall. I don't seem to recall anything else.
Yeah, well, he became deputy president of the country after the 2014 elections. Yeah. So that might tie up with your statement in paragraph 18 of your statement. Mr. Seleka, is my recollection about Mangaung correct?
It is correct. The date from the president's own affidavit, his election being elected as a deputy president of the ANC, it's 18 December 2012.
Yeah. Okay, all right. Now, Mr. Ephron, going back to the non-comprehensive due diligence exercise, as I understand it, that you say was undertaken by Glencore, you obviously did see the coal supply agreement that you would be taking over from when you acquired OCH and OCM, is that right?
Correct.
Yes. Now, I note that in paragraph 14 of your first statement, you say you did not, for example, or Glencore did not, for example, know how any price adjustment mechanisms in the coal supply agreement worked. Why didn't Glencore find out how those mechanisms worked? I would have thought that would be simple.
Yes, because that information was not disclosed in any of the pre-listing statements or publicly available information, and therefore we could not have known that.
Now, did you say you didn't approach, that is Glencore didn't approach OCM directly as a company, but it approached shareholders privately? Is that correct?
Correct. That's correct.
Yes. And you say that was because if you approached the company directly, that would have triggered some notice that would have to be given, and that would affect the share price. Is that right?
That's correct.
Yes. But you did have sight of the coal supply agreement. Is that correct? You just didn't know how the mechanism worked.
No, that's incorrect.
You did not?
No, so we only would have had, we did not have sight of the coal supply agreement. We would only have had sight of details in the competent persons report of the coal supply agreement, such as volume, duration, and price.
Yes. Does that mean that that was just one agreement that you didn't have sight of, that you would in effect be taking over, or is the position that you didn't have sight of any agreements that you would be taking over when after acquiring OCM?
We wouldn't have had sight of any confidential agreements that OCH would have had. Only the main details of significant contracts and deals that OCH had.
Well, it sounds strange to me. I think you said it's normal to do things this way, but it sounds strange to me because...
No,
or did you not? Am I
didn't say it. No, I didn't say it was normal. I just said that it happens, and it's quite common that potential acquirers of a company don't go directly to a company. So let me just shed a little bit of light. If you go directly to a company,
yes,
it takes
do.
it to the board. The board then may turn around and say, you know, why would we do a deal with one prospective buyer? Let's open this up to a tender process. Let's look at the entire market. Let's look at potentially the better value. So by going directly to a company, it's a strategy. If you can sign an exclusivity with a company, then maybe it's a good strategy to take. But if you can't, and we didn't feel that we could, then it would have opened up a sort of Pandora's box in terms of potential competition. So we felt that the strategy was more prudent to go directly to shareholders that own the shares in OCH and effect transactions with those shareholders. We've done it before at Glencore. This is not the first time that we've done such a transaction.
Yes. Okay. No, I understand that I was attributing to you something that you had not said, that it's usual, but you say, I think the line between what you say and what I was attributing to you is quite fine. You say it does happen, and you say it is common, the approach to the shareholders as opposed to approaching the company. Okay, all right. Now,
correct.
one of the reasons why, certainly from my perspective, it was important that you be called back is that certainly when you gave evidence and maybe when other witnesses gave evidence, I had this feeling that OCM, Glencore, might have been treated rather harshly or unfairly or maybe too firmly by Eskom when you invoked the hardship clause. Of course, when Mr. Brian Molefe came and gave evidence, and you might have had him, or you might have had the chance to either listen or watch or read his evidence, he referred to something that I said at some stage, and I can't remember whether it was when you gave it evidence or somebody else, when I questioned why Glencore had not done a due diligence, but maybe with what you are saying now, I must say why it had not done a comprehensive due diligence, because you say it did do a certain type of due diligence. It's not as if it didn't do it at all, you know. Now, but when Mr. Molefe gave evidence, he in effect said, not in so many words, but he was sending a message that says, Glencore OCM don't deserve any sympathy. To say the least, they put themselves into this position. They didn't do a due diligence, maybe we should say, didn't do a comprehensive due diligence. They took over a coal supply agreement that had this clause about price, and they then complained that this price was bringing them hardship, and they wanted Eskom to increase the price quite drastically. And he said, I refused, because it was going to be unjustified for me to get Eskom to increase the price like this. But his evidence, together with that of Mr. Koko, when the two at least are read together, also says, but hang on, if Glencore OCM felt that there was unfairness in us sticking to the price that was in the agreement had a way for them to get relief. The agreement said you can invoke the hardship clause, which they did invoke, but it says if there's no agreement, you can go to arbitration, take arbitration to its finality. And if the arbitrator, who would be a neutral person, thinks that yes, there's been harshness on you, relief will be granted. And they were saying, but at Glencore OCM, although they invoked the hardship clause, and although at some stage they took steps to pursue the arbitration route, they never pursued it up to its end. And Mr. Koko says, Chairperson, do you know why they didn't do that? It's because they knew they had no case. Because the agreement, or I don't know now, I may be referring to the settlement agreement that they referred to, defined what was excluded from the hardship clause. So he says, excuse me, he says they knew they didn't have a case of any hardship. That's why they didn't pursue the arbitration route to the end. So in other words, saying to me, Chairperson, in effect, whatever sympathy or unfairness you may have felt for Glencore stroke OCM when Mr. Ephron gave evidence here, and maybe whoever else gave evidence was misplaced, because they placed themselves in this situation, and for the situation that they were complaining about, the coal supply agreement had an escape route being to go to arbitration, and then you could get relief. But they didn't do their job. Now they wanted Eskom to accept an increase, an unjustified increase in the way they put, certainly Mr. Molefe put it. So do you want to address that that criticism or those that
yes.
evidence?
No, I do. You've raised numerous points, Mr. Chairperson. So
yes,
I have to try and recall. You've raised a lot of points that I thought we would individually go through, but I'm happy to do so.
Okay, what I want you to do is deal with them to your satisfaction, but Mr. Seleka might individually raise some of them, but deal with them the way you would like to deal with them.
Okay, so let me try and again give you my perspective in order to refute some of the allegations that have been made. You have to go back a step. The CSA contract between OCM and Eskom was entered into in 1993. It was a 25-year agreement. The people that entered into that contract envisaged that situations and circumstances will change over a period of 25 years. And as such, they included a hardship provision. When Glencore came into the company in June or in March 2012, we started to understand more and more about the contract. We, of course, identified that there was a hardship clause. Now, Eskom is a business and Glencore is a business. The contract had been running for 19 years. The contract specifically makes mention under the hardship provision, and I need to read this again because for some reason people seem to forget the severity of the situation. I'm referring to paragraph 12 of my second statement, and that would be on page 324. Are you with me, Mr. Chairperson?
I'll get there just now. Yes, I'm there.
So the CSA between Eskom and OCM included a hardship clause, which specifically provided that.
And that is
and
paragraph 12.
Quote from the contract. Now, exactly, it's paragraph 12.
Mm-hmm.
In entering into this agreement, the parties declare it to be their intention that this agreement shall operate between them with fairness and without undue hardship to any party. That is the prerequisite of the hardship clause in the CSA between OCM and Eskom. So on the back of that, we instituted hardship, and we knew that it would be a long and tedious laborious legal process with Eskom. We understood that. It was then, in early 2014, and I'm going to have to refer you, we're jumping to my first statement now, paragraph 20, and I'm going to get you to the page.
Page 4.
Thank you. Page 4, okay. Paragraph 20. Please can confirm that you're with me, Mr. Chairman,
yes,
Mr. Chairperson.
Yes, I am. Thank you.
Okay. So approximately 6 months after discussions and a hardship notice had been sent, Eskom then approached OCM to suspend the hardship arbitration and to come up with a proposal to ensure the viability and the longevity of the mine, and at the same time secure the much needed coal required for Hendrina Power Station. Why did Eskom do this, in my opinion, is that Eskom realized that there was severe hardship being incurred by OCM, but Eskom also realized that that contract would be coming to an end in December 2018, and under a cooperation agreement, which was signed in that paragraph on the 23rd of May 2014, we agreed that we would suspend the hardship in the hope that we could negotiate terms where the original idea, and it's not exactly written in these words in my statement, was that we would recover our costs for the period 2014 to 2018, and then we would extend the contract with Eskom at advantageous prices to Eskom for the period 2019 to 2023 or 2024. So we like to see it as a win-win. At the same time, there were a number of penalties and a number of other things that we were hoping to incorporate some resolve and settlement on that. So when we looked at this and we said, can this work? Or when Eskom looked at it, they said maybe there would be some upfront pain in terms of paying a higher price in the interim to ensure the viability of the mine. They would in turn receive approximately 25 or 30 million tons to see them through to the end of the life of project of the Hendrina Power Station. Of course, I'm going to add, with the benefit of hindsight, it would have been an incredible deal for Eskom today. That's another issue. I'm going to jump forward. When the new management came into Eskom and looked at the cooperation agreement, it was their decision. They decided, in their view, that they could not pay a higher amount in the short term, and they wanted to end this cooperation agreement. They did not want to continue. They felt that they would take their chances in 2018, and it was their view that they did not have to continue. We felt it was unfair. We felt it was unreasonable. We explained it to them in the best possible terms that we could. We had meetings, we sent letters, we opened up the books of Optimum to show them the hardship. We showed them what was happening in the mine. Needless to say, we received a letter from Eskom, paragraph 36 of my first statement. It's page 9.
I've got it.
We received a letter on the 22nd of June where Eskom indicated that they no longer wish to participate in the settlement process and that the cooperation agreement essentially ended at that point in time. And we go on to say in paragraph 37, while Glencore and OCM understood that Mr. Molefe was entitled to his position and how that position might benefit Eskom in the very short term, that Eskom would continue to receve coal at low prices. We felt that Mr. Molefe's position did not necessarily appreciate the risk that Eskom faced after 2012, where they would have no security of coal supply for the mine, which was located very close to the Hendrina power station, and therefore would be in a very weak negotiating position. That being said, that was Eskom's response. And that was sent on the 22nd of June, 2015. I now refer you to paragraph 39. The very next day, Glencore re-invoked and reinstituted the hardship arbitration. The very next day. At no stage was Glencore going to give up on the hardship. At no stage. So the allegations that Glencore wasn't going to go down the hardship road, there is absolutely no doubt in anyone's mind, including the members, including the directorship of Eskom, that Optimum was suffering severe hardship. Eskom made a decision. Eskom decided that this was not the road to go down. They didn't want to do a longer term deal for Optimum. They only wanted to worry about the short term. At the same time, there was a hardship provision. Had we gone down the road of arbitration, it could have gone either way. Of course, as arbitrations can always go either way, but we felt that we had a more than reasonable chance of succeeding in arbitration. And that's the crux of the story. Mr. Seleki, I'm sure I've touched on a lot of points that you want to to jump in on.
Mr. Ephron, Mr. Seleka is looking at me because I asked the question. He's looking at me.
I can follow up.
Well,
it seems to me that you've become the evidence leader, Mr. Chairperson.
Well, you might not be, you probably mean that well, but there may be others who would not mean it well.
I do, of course.
So the first time you invoked the hardship clause, was it 2013 or was it when was it?
Correct. It was 13th of July 2013.
Yes. And the cooperation agreement was signed when?
It was signed in...
Not necessarily the exact date, just...
23rd of... I've got the exact date, 23rd of May 2014.
Oh, okay, all right. So it might be fair to say there may have been around a year, close to a year or thereabout, when the cooperation agreement was signed, if you calculate from when you had invoked the hardship clause for the first time. Is that right? It might be less than a year,
yes,
but close to that, yeah. Okay, all right. Now you may...
Yes, and the arbitration proceedings were going ahead during that time. And I need to reiterate that Eskom approached OCM in early 2014. We only signed the cooperation agreement on the 23rd of May 2014, but early 2014, as per my paragraph 20, that's when Eskom approached OCM to suspend the hardship.
Okay, so are you saying that after the invocation of the hardship clause by OCM in 2013, the process that would have led to arbitration continued while discussions or negotiations were going on between OCM and Eskom, but before the arbitration could happen, the two parties concluded the cooperation agreement. Is that what you say?
Yes, after Eskom approached OCM, that's exactly what happened.
Yes, and then the cooperation agreement suspended the hardship clause, and then that went up to, is it 2015 when the cooperation agreement was cancelled?
Yes, 22nd of June 2015.
Yes. And thereafter, I think you said the following day, you, OCM re-invoked the hardship clause, is that right?
That's correct.
Yes. And before Mr. Seleka asks you the questions he's going to ask, can you indicate to me whether when OCM re-invoked the hardship clause after the cancellation of the cooperation agreement, did that mean the continuation of the process that had been suspended when the cooperation agreement was signed, or did it mean invoking the hardship clause from the beginning? In other words, starting the process afresh? Or is that something you can't remember?
No, no, I can recall exactly. It was not starting afresh. Everything that had been done already from July 2013, we had just continued. In fact, we had set down dates for arbitration for a year hence, which was the 16th to the 27th of May 2016. So we were trying as much as we could to speed up the process. Of course, Eskom was trying as much as they could to slow down the process.
What then led to, why did the process not reach actual arbitration? Because the company
went into business rescue.
Yes. And that, of course,
the company went into business rescue later that year.
Yes, that later in 2015.
Correct.
Yes. The company going to business rescue was, as I recall, OCM / Glencore's decision. Is that correct?
Correct. Well, it was all the shareholders. It was all the shareholders of OCH would have made that decision.
Yes, but
not just Glencore.
Well, what I'm highlighting is that it wasn't a situation where some third party, maybe a creditor of OCM, initiated that. That was not the situation.
Well, there were circumstances. The board decision, the board of OCH and OCM would have made the decision, but it would have come as a result of circumstances within the company. So it wasn't from an outside party.
Yes, Mr. Seleka.
Yes, thank you, Chair. I think
I leave a lot of questions to you.
No, that's fine. People must understand this is an inquisitorial investigation, Chair. So when you ask questions, you are not necessarily taking over from the evidence leaders. You're working with them. Mr. Ephron, I'm gonna, let's see whether I'm not disturbing that sequence. But there's an issue here in regard to the hardship, the invocation of the hardship clause, and the referral of the matter to arbitration. That the knowledge on your part, and I'm putting a version to you from one of the witnesses, was that you could not prevail in the arbitration because of the reason why you invoked the hardship clause, which was the export market was down, and you had closed your export market component of the mine. The agreement specifically says in clause 27 that the downturn in the export market is not the reason to invoke a hardship clause. And I want you to comment on that, because if that was the reason, the allegation is that you then knew that you would not succeed in the hardship arbitration, and that's why you did not pursue it. Yes.
That's not the reason. The reason why the hardship was invoked was because the price escalation mechanism in the contract was not reflective of the current situation with respect to mining costs. And to be fair to the people that entered into this contract in 1993, there is no ways that they could have envisaged that the price escalation clause could encapsulate all the necessary increases or all the increases that incurred in mining from 2008 and onwards, and even before. And as such, every year in real terms, the price that the mine was receiving was getting less and less as a result of the price escalation adjustment not being reflective of mining inflation. So what then happened was that the mine, as a standalone mine, or as a fact, or with the export product, was losing money. So it was losing money on the basis of the fact that this escalation clause was not representative. And for every ton that was being supplied, the mine was losing a significant amount of money.
What do
I
you
hope
say?
I'm answering you.
Yes, okay,
correctly.
I thought you had not finished.
Well, I hope I'm.
Yes, I thought you had not finished,
No,
but I think you have,
I'm,
yeah.
I'm,
What do you say to...
no, I'm done.
What do you say to the proposition that whatever difficult situation OCM/Glencore found itself during this time was to a very large extent a consequence of the choice that OCM/Glencore or Glencore had made when it acquired control of OCH and OCM, not to get to know, not to see this contract, CSA contract, and not to study it carefully and see how it would work for Glencore OCM and what potential challenges it would pose, and what Glencore would put in place to deal with those challenges. What do you say to that proposition? To say, when
Mr.
you,
Chairperson,
hang
Mr.
on,
Chairperson,
let me finish. In other words, what do you say to the proposition that you should not complain, or OCM Glencore should not complain when it met with such challenges as you have told me about? Because that is what is going to happen if you acquire a company without ensuring that you see what contracts it has that will be binding on you, and whether it will have challenges and how you will meet those challenges when they do arise. This is a situation where Glencore was the author of its own misery. What do you say to that proposition?
Mr. Chairperson, you're correct. You are 100% correct. There was a risk associated with entering into agreement to buy shares in OCH without performing a comprehensive due diligence. There was a limited due diligence, and I've explained that extensively. Of course, we did not know the extent of the losses that were being potentially incurred by Optimum. But the key matter here, and this is what people are forgetting, is Glencore only complained in terms of the way in which Eskom approached this matter. We looked at the contract, we saw that there was a hardship clause, and we invoked hardship under the rights of the contract, because the people that entered in this contract envisaged that there would be problems with this contract. So all we did was we stepped in and said, how can we try and ameliorate the risk or ameliorate the financial difficulty that the shareholders of Optimum were experiencing at that point in time, using a contractual basis to do so. That contractual basis was a hardship clause. Now, if Eskom felt that that was not what they wanted to do, or not the road that they wanted to go down, or they felt that it was unfair that we invoked that, well, that was sitting in the contract. So that was a mechanism that we decided after the fact to use to reduce the amount of financial hardship we were incurring. At the same time, we put a proposal to Eskom that said, let's extend the contract, let's try and make it into a win-win, but we need to do something, because right now we are funding this entire operation, which ordinarily should be in liquidation, but we're not, because we want to try and continue and ensure that the mine supplies coal to Eskom. So we're not denying any of those facts. We business people, we came in to look at the mine, we looked at the mine, and we saw that there was a mechanism that allowed us, because we were incurring undue hardship, there was a mechanism that allowed us to look at the contract and try and see if there was a way in which we could reduce the hardship for the mine. That's all we did.
Well,
now, there's another issue regarding whether there was malafides, or whether there was whether we can complain or not complain. We're not here to complain. We're not here to complain. If that was Eskom's decision, that was their choice. That was what we had to live with. We reinstituted the hardship clause. We had dates set for hardship, and we were going to continue down that road. That was the intention.
Yes, of course, all of this arises, at least in part, because Mr. Brian Molefe says, in effect, if not expressly, that he or his management, after he came to Eskom, is portrayed as having been harsh or unduly harsh in his approach to Glencore Eskom in regard to the issue of increasing the price as requested or proposed by Glencore. It is said that prior to his arrival at Eskom in April 2015, the management of Eskom had discussions with Glencore / OCM that reached a cooperation agreement, in terms of which, and which I think you said when you gave evidence previously, in terms of which all the structures within, management structures within Eskom who had anything to do with the cooperation agreement and with the, I think, price you were proposing, they seemed to be amenable, or they were agreeable, until Mr. Molefe came, and when he came, all of that changed. So he is saying, I'm not denying that I took a firm stand against increasing the coal price, and I will not apologize for that position that I took. He says, I took that position in the interest of Eskom. There was no way Eskom could afford that price increase, and he says, actually, that proposal was unjustified, and it's unfair that decisions that I made, or decisions that my team made, should be viewed as decisions that were aimed at unduly being harsh on Glencore / OCM, because maybe we were wanting to assist another party. We wanted to put OCM or Glencore in a difficult position to facilitate some other transaction. He says that's not the case. He says, I looked at all of this, I looked at the agreement, and I looked at Eskom's financial situation, and I did what I believed was right in terms of protecting the interests of Eskom. You might wish to say something. I'm just saying that's the context in which some of these issues arise. You might wish to say something about this.
Yes, sure. So, Mr. Chairman, I mean, that's Mr. Molefi's view, and he's entitled to have that. But I think you've heard a substantial amount of testimony from other board members and other people within Eskom that the approach that he was taking was unreasonable. But there's no reason for me to say to try and get to understand whether Mr. Molefi feels he was right or wrong. That was his opinion. I think in hindsight, we can see exactly what's happened to the mine. The truth of the matter is that Mr. Molefi had come in, and within a few days, he had already decided that he wasn't going to go ahead with this agreement in any form. The cooperation agreement had even been extended to a fourth addendum of the agreement. In fact, most of the terms had already been agreed in terms of the extension of the CSA until 2023. And that's in my first statement, paragraph 27. So if at the end of the day, I can't make any deduction of what Mr. Molefi felt or what the internal bureaucracy of Eskom felt. But we said, fine, if that was your position, then that's what we would have to live with.
Okay, Mr. Selega.
Thank you, Chair. To the extent, Mr. Ephron, that you recommenced the hardship arbitration, you say the next day after the termination of the settlement process. You got dates in your statement, 16 to 27 May 2016, which is nearly a year later. Could you not get earlier dates for that arbitration?
Mr. Chairperson, you couldn't even get a meeting with Eskom, never mind a date. I mean, we were lucky to take whatever we could get. Remember that between the 23rd of June and 23rd of June 2015 and May 2016, there would have to be discovery, there would have to be a whole lot of witness statements. So, I mean, we got those dates and we locked them in. There wasn't a question of getting an arbitration hearing sooner than the 16th and the 27th. I can assure you we did everything in our power to try and get that date sooner. And Eskom were doing everything in their power to get the date later.
You earlier responded to the chairperson's question, why didn't you pursue the arbitration to its ultimate end? Your response was that OCM went into business rescue.
Correct.
Now, what do you say to both Mr. Molefi and Mr. Koko, who say, well, business rescue was simply used as a mechanism for you to, OCM, for OCM not to comply with the agreement, which OCM knew it could not terminate. So neither party could cancel the CSA, and for OCM to avoid complying with the CSA, it then decided to go into business rescue. So it's a stratagem, in other words, business rescue proceedings.
So I'm not sure what agreements either Mr. Molefi or Mr. Koko read, but I don't know many agreements that allow you to exit. So I don't know, the accusation that we realized that we could not exit the agreement, we then went into business rescue. Business rescue was instituted by the board of OCM and OCH as a result of circumstances that led up to the business rescue being declared on the 31st of July. But if you allow me, after the hardship provision had been invoked And after we had received a letter from Eskom that indicated that there would be no cooperation agreement and that there would be no fourth addendum to the CSA, we then received a letter on the 16th of July, just a month later, 16th of July 2015, and I'd like to point you to paragraph 42 of my initial statement.
Page 10.
Sorry, page 10, sorry.
I've got it.
OCM received a letter from Cliff Decker Hofmeyer, representing Eskom, demanding payment of alleged penalties in an aggregate amount of 2 billion rand. And that was for previous sizing and quality issues. These were the sizing and quality issues that we were continually discussing with Eskom over the past 3 years in order to come up with some sort of amenable solution. The key thing was not the penalty. The penalty we knew was not based on anything reasonable. And I think that there's been some evidence that within Eskom, that many people within Eskom felt that the penalty of 2 billion and the request for an immediate payment, otherwise summons will be issued, was completely unreasonable within Eskom. So that we've gleaned from other evidence and other testimony that's given to the commission. But that wasn't the issue. The issue that put us into business rescue was the fact that continual penalties would be applied against the contract, against any deliveries, which was approximately 3 to 350,000 tons a month, that was being supplied by OCM at the time, that Eskom would no longer be paying for that coal. Now, we'd gone down a long road of explaining, and we had experts and predictions and reserve indications and all details regarding the qualities of the coal and the qualities of the sizing. That being said, it was virtually impossible for OCM to supply exactly as per the contract. It was still a very, very high quality coal. But by the imposition of the penalties and the mechanism in the contract allowed for set-off, which meant that if we were supposed to get 150 Rand a ton, Eskom would pay us nothing for the coal, essentially 1 Rand a ton. I'd like to point you to paragraph 47, which is on page 12.
Yes, I've got it.
Further malafides, as far as I'm concerned, that was imposed on OCM. Eskom withheld payment for no reason of approximately 92 million Rand, which was for coal that had been delivered for the previous 2 months.
Sorry, we now are you reading from?
We've got this letter.
Sorry, Mr. Ephron.
I'm reading from. So in paragraph 47.
Yeah.
I can read it for you, but basically what it says is that for the month of July and the month of August 2015, Eskom did not pay for the coal. Coal delivered.
Hang on, you were referring to 90, I think, was it 92 million or something? And I was trying to look at 47.
Yes, so 58.
I could not see it.
So 58 million for July.
Yeah.
And 34 million for August.
Okay, all right. Continue.
So we then knew what was happening within Eskom. Eskom was just trying to put the maximum amount of pressure on Optimum. They sent a letter for the penalties of 2.1 billion Rand, which we knew was frivolous. They then purported to not pay Optimum for the coal that was being supplied. Nothing. Never mind the hardship, but they would no longer pay for the coal. They withheld the money. So the directors of Optimum at that point in time, in order not to trade recklessly and speaking to shareholders, were left with no choice but to place the business into business rescue in the hope that the business rescue practitioners could come in and maybe they could salvage something from the disastrous situation that we were faced. That is why we did not continue with a hardship claim, Mr. Chairperson.
I'm sorry. If you sum that up, would it be that because of the introduction of the element of the 2 billion rand penalty claim, you felt that that changed the situation, and OCM stroke Glencore would not be able to
So we were
deal with that, except through business rescue?
Correct. We were faced with, we were up against the ropes. They knew we had hardship. They had done full financial due diligence on the company. They knew exactly what was happening. They knew that the hardship arbitration was going to continue. They still elected to hit the company with 2.1 billion of penalties, which they knew the company could not afford. And in addition to that, the way which we understood it was that Eskom would not then be paying for any of the coal that was being supplied. So we were left with very little choice, Mr. Chairperson. Very little choice. As directors, we were really up against the wall. And we still held out hope. We still came in and gave post-commencement funding or post-business rescue funding in the hope that something could be salvaged via the business rescue practitioners.
I take it that OCM stroke Glencore, when this demand for the payment of 2 million rand was made, 2 billion rand was made, OCM would have looked at the merits or demerits of that claim and taken legal advice where necessary as well, and would have formed a view about the merits or demerits of such a claim. And I would imagine that if they took the view that there was no merit in a claim for 2 billion rand, maybe it was 1 billion rand, substantially less, or not valid at all, that they wouldn't feel pressure to do anything. They would say, well, take us to arbitration for that penalty, for that claim, or take us to court. We will defend that. We are not shaken by that claim. Am I right in thinking along those lines?
So there is that. It's a little bit more complicated because there are two aspects here. The first aspect is we've been in discussions with Eskom to attempt to try and reduce minimally some of the penalty provisions in the contract, because as the mine grew over the previous 20 years, the coal was further and further away from the plants, and there was further and further degradation of the material, and it was virtually impossible for Optimum to meet the exact quality specifications. I say this not with a pinch of salt, but the qualities were very, very close to what needed to be supplied under the contract. But because of the very harsh penalties that were included in the contract and were already under negotiation between OCM and Optimum, that there was reasonable chance that we would not have to pay such a penalty. But of course, it's another legal obstacle that the mine would have to face. And there would be possibility that some of it would have to be paid. We don't know, but there would be. At the same time, there is a mechanism in the CSA that allows OCM to approach Eskom, to explain to Eskom, and Eskom had brought their experts onto the mine for over the last 3 years and they had agreed. I mean, the Eskom technical people had agreed that what Optimum or OCM was saying with respect to the qualities of the material was correct, and that they could not meet the harsh specification that was included in the 25-year-old contract. So yes, in one instance we could defend it. It would be it would be a long story and it would be defendable. And we felt that maybe there was some to be paid, certainly not 2 billion. The bigger issue, Mr. Chairperson, was that while we're waiting for that to happen, while we're waiting for the hardship to happen, we're mining 350,000 tons a month of coal, already losing 100 million rand a month, but now we're going to lose 200 million rand a month because Eskom's not paying us for the coal. So you could say it's an easy decision, defend it, but when you're faced with such severe hardship within a particular company, there comes a point in time that you reach out to business rescue practitioners in the hope that maybe they can come up with something more suitable than you. Maybe it was a personality clash between OCM and Eskom, and maybe another person would be able to get a better deal. I mean, I'm sure that there are deals in the industry being done as we speak around these kind of transactions. I wouldn't be surprised.
Maybe
anyway,
we should.
That was the story.
Thank you, Mr. Ephron. Maybe let's take the tea break now, and then we'll continue after the break. Let's resume at 1:45. It's 25. No, not 25 to. It's 27, 28 minutes to 12. Let's resume at 1:45. We adjourn.
there was no option to exit. I mean, what I mentioned earlier was that I don't know of any agreements that allow you just to exit if you want to exit.
Well, you
Maybe they are.
No, the normal thing is that different agreements have different or make different provisions, but it's quite normal for an agreement, speaking in general. I'm not talking about a coal supply agreement necessarily, to make provision, particularly if it's a long-term relationship, to make provision for any of the parties to exit by simply giving a certain amount of notice, a reasonable notice that now they want to get out of this contractual relationship. And in addition, the normal thing, what I'm talking about is a situation where they don't need to blame the other party for anything. They just say, we want to exit for our own reasons. You know, we're not saying you are in breach or anything. And then obviously there would be also clauses to the effect that if the one party is in breach of the agreement or contract, the other party, the innocent party, is free to exit the contract by terminating the contract if the breach is a serious one. That is the norm. That is what is normal. You know, that happens with the contract of employment. Having been CEO, you would know. If you have a fixed term contract with a particular employee that he or she is employed for X number of years, usually the only way you can, either the employee or yourself can exit that contract is if the other party is in breach, but not just because you no longer want to, because there is a reason why both parties want a fixed term arrangement. But if it's a contract that is of an indefinite nature, usually you can exit by giving notice. But as I understand it, what Mr. Koko was saying in regard to the CSA was because of how long it is, the duration of the contract, and because of the importance of coal to Eskom, there was no provision for just exiting, you know, just because anybody wanted to exit from it. Obviously, that brought about certainty to both parties. But also, he was saying the agreement acknowledged that there could be situations where there would be hardship on the part of, I can't remember, or either side or the supplier. And that is why a special provision was made for the hardship clause, because it was understood that you can't have a situation where the one party feels that there is hardship, but they are forced to just continue without any route to relief. And it was accepted that where the one party feels that there is hardship on it that has come about in relation to the contract, then it could invoke the hardship clause, and that would have the potential of leading to relief that would remove the hardship if they were successful in arbitration. But I had also understood you to be suggesting that there was a way of exiting, but I think now that you have clarified, you were simply saying you don't know of situations where you can just exit. I understood you to be saying something different, but you have clarified that your understanding was that OCM Glencore could not just exit the CSA, and that's the understanding you had.
Can you explain that, Mr. Ephron?
Correct, Mr. Chair. If I can add,
Yes.
if I can add, Mr. Chair, in my experience with Eskom over many years, I've never seen a contract that allowed one party to exit. Of course, under the second example that you gave of breach, of course, that's a different story, and that goes into a whole another set of legalities.
Yeah.
But in terms of unilateral ending of a contract, I've never seen that. I've never seen that in Eskom, ever.
Yeah. Okay, no, that's fine. Mr.
And there's
Selega.
there's no reasonable way. There's no reasonable way of any. There's no way any reasonable person can deduce that someone who's been in the industry for many years would ever suggest that there would be such a contract between Eskom and a supplier.
Yes,
It doesn't make any sense.
No, I certainly understand completely why there is no such option. Having had the evidence of Mr. Koko and Mr. Brian Mulef, and now your own position, I have a complete understanding why there would be no option in the contract to unilaterally get out of the contract.
Yes. So,
Yes, but sorry, just to not to harp, but the allegation that we assumed that there would be such an option is preposterous. It's bizarre. Anyway.
no.
Well, one, I don't think that either Mr. Brian Mulef or Mr. Koko said you thought that there was such an option. What we have said is that both Mr. Selega and I thought that you had said earlier that there was such an option. That's why he asked you the question. So, but you have clarified now, but I don't want you to get the impression that it's witnesses who said that.
Okay, all clear.
Yeah. Mr. Ephron, the allegation is actually different. Now that you say you couldn't, or there was no option to exit, let's see how you answer this question, because I asked you earlier. Was that because of that knowledge, you used business rescue as a mechanism to avoid complying with the agreement?
Mr. Seleke, I think I answered that in my answer to the chairperson, in that business rescue was the final straw on the camel's back in terms of the severe hardship that OCM was under at that point in time. It had gone through an extensive process with Eskom, from hardship to cooperation agreement, to addendum, to discussing the penalties, to extending the contract. There was a significant history, and it was the catalyst of the penalties and the going forward of the non-payment of coal deliveries. We put the business in business rescue because our shareholders were no longer willing to fund the business on a monthly basis. We got to a point of, in some respects, no return. And there was hope that during a business rescue proceedings, and that's why there is such a thing, is that a business rescue must rescue the company. And we gave the business rescue practitioners all the means that they would have required in order to hopefully come up with something.
So your answer to that allegation is, yes, you used it as a mechanism to not comply with the agreement?
No, my answer to that is no. No, my answer to that is no. We did not use it as a mechanism. We used business rescue because the company was in financial distress.
Well, let me ask this question, Mr. Ephron, and maybe I must just say to you, because not everybody knows, in my earlier life, I was a lawyer in practice, and I represented a lot of trade unions and did a lot of labor work. So I became familiar with bargaining between trade unions and employers and negotiations for all types of things, including wages and struggles for recognition agreements and so on in the 80s and 90s. Between a trade union and an employer, there is a lot of bargaining because each one is trying to advance its own interests. And in a mature relationship, neither would be trying to destroy the other because they need the other, or at least they think they have to live with the other. And but in trying to advance their own respective interests or promote their interests, they can cause a lot of inconvenience for the other. Each one can cause a lot of inconvenience and sometimes cause some suffering and some hardship. As a result, when a trade union calls its members out on strike and they go for weeks or months without wages, that's some suffering, but the employer can also lock them out. So there can be a lot of suffering, and the employer may go through suffering when there is no production because the workers are out on strike and each one blames the other, you know. But within that, there is a lot of room where various things are allowed to be done by both parties to the other. And they will accuse each other of being unfair and so on. But sometimes, or most of the time, one should leave the whole thing to them, and that's a way in which they will push each other to an agreement, to compromise. Now, when one looks at the discussions and negotiations between Eskom and OCM and Glencore here, including the use of the business rescue option, whatever the reason may have been, if the agreement did not preclude Glencore or OCM from invoking the business rescue process, it can be argued that there was nothing wrong with OCM/Glencore invoking the business rescue process if it believed that the circumstances required it to do so. Okay, but if the parties didn't want a supplier who is involved in a coal agreement such as this to voluntarily resort to a business rescue process, maybe they would have put that in the agreement, or maybe they would have said, before you can do that, the following steps should be taken. Maybe they would have said, well, it should be a situation where it's a third party who puts you into a business rescue situation. I'm not sure. I'm just opening my mind to a lot of possibilities. Is there any reason why, when I look at all of this, the allegations that have been made by OCM/Glencore against Eskom, particularly after Mr. Brian Molefer's arrival, as well as when I look at the allegations that are made by Eskom, particularly during Mr. Brian Molefer's tenure, against Glencore stroke OCM. Is there any reason why I shouldn't approach this on the basis that this was a commercial transaction where each party was entitled within certain parameters to use whatever tactics to bring pressure on the other to see things their way or to compromise and reach agreement without attributing any malafides to either party? Is there any reason why I shouldn't approach the matter in that way?
Mr. Chairperson, I can't deduce what you should be thinking or the way in which you should understand this. But, and just to be clear, we're not making allegations of malafides because we don't know malafides. We're only putting facts on the table, and it's for you to come to the conclusion of whether there was or there wasn't. But there are a lot of facts and there's a lot of information at your disposal as to what was happening with this mine and why so much pressure was being put on this mine. When you say you had a lot of experience with unions, we also had a lot of experience with unions over the years, but I always knew that fairness would prevail. Even though many of our workers went out on strike, I always knew that in the end we would both be reasonable and come to the party. If there is an allegation to be made, we don't believe in reasonableness in terms of OCM and Eskom. Because why put so much distress on a company when you know that the company's under distress? Why? For what purpose? There was a solution. There was a reason. There are currently deals being done in the industry at the moment that allows for such solutions. So why couldn't a solution be done in 2015? So I can't guide you in terms of how you want to, of how you should think this through. But I can only give you our version of the facts and where we stand and what we experienced at the time in the most honest and open way that we can do it.
Yes, okay. Mr. Selega.
But on that question, Mr. Ephron, the executives we have mentioned, Mr. Brian, Molefe, Mr. Koko, and I think one member of the board, Dr. Ngubane, did say something to the effect that Glencore was seeking to capture Eskom. You were strong-arming them into increasing the coal price, and that's the reason why there was some resistance on their part.
And I think the increase was said to have been, is it close to 100%?
Yeah, it's more than that. It's
yeah. So part of what was said by Mr. Brian Molefe, Mr. Koko, and Mr. Dr. Ngubane is look at the increase that Glencore wanted us to agree to. Look at the amount. How could we agree to such an amount if we were really acting, if we were really to act, and we seem to be acting in the interest of Eskom? You want to deal with that?
Sure. Mr. Chairperson, they have their view on the price increase. The price increase, in fact, the final price increase that we gave was, I think, 300 Rand a ton, which was, yes, 100% more. It was all in relation to the costs of the mine. The costs were evaluated on an open basis with Eskom's experts to see exactly what was happening. The allegation of state capture is so preposterous that it's very difficult to try and even mention it, because all Glencore did was come in. They saw a contract that was a mine that was under distress. They saw a long-term contract. They saw a hardship invocation clause. They saw a clause that could relieve some of the pain which was envisaged in the contract in 1993. And all they intended to do was invoke a contractual provision in a contract. If that is state capture, then I certainly don't understand state capture. Because in my mind, how does one, who are we capturing in this instance in terms of asking for a price increase? And I want to reiterate this because it seems to be lost all the time. There was a win-win scenario in extending the contract by an additional 30 odd million or 25 odd million tons, which would see out the life of the Hendrina power station. So there was a win-win scenario. It wasn't just a one-sided discussion. Now, these kind of discussions, Mr. Chairman, are happening every day between Eskom and other industry players as we speak. Why is it okay today and was not okay in 2015? Was it state capture in 2015 and not today? So I don't understand the allegation, and I strongly deny it.
What do you say to somebody who says to you, listening to all of this evidence, it seems that if OCM or if Glencore had done a proper, maybe I shouldn't say proper, a comprehensive due diligence before taking over OCM, OCH and OCM, and had seen this contract and had done their homework properly, they would have realized that in due course they would have a problem because of this price and would have stayed away from OCM. But because they didn't do their homework properly, they didn't know before taking over OCH and OCM that there was this contract. You did say that you didn't know, you had not had sight of this contract. You didn't know the terms of this contract. You didn't know that the price adjustment mechanism was one that you would later find not to be, I think you say in your statement, not to be helpful or whatever. It wouldn't help in this situation. That's why you found yourself in this situation, because you didn't do the kind of homework that should have been done. What do you say to that?
Firstly, Mr. Chairman, anyone, even if Glencore had not bought this mine, whoever had taken on this, the current management would have declared hardship. The current management would have gone into business rescue. Anything could have happened. So it's difficult to go back in time and say, had we done this, we would have done that. I don't think anyone is necessarily to blame in that instance. What we did was we came in, there was a risk of the contract, as you quite correctly point out, and all we did was, when we came in, we used the contractual terms of the contract to try and reduce the hardship of the mine. That was our intention. Our intention was not to come in and change the price or close the mine. That doesn't make any sense. Our intention was to come in and continue with the contract. There was no reason why we were not going to continue with the contract. When we saw that there was undue hardship, and when we saw that there was a hardship clause, we invoked the hardship. I don't think that is unreasonable in terms of any counterparty in any contract wanting to do in a 25-year agreement. So you can blame Glencore for not doing a full due diligence, but at the same time, how do you blame Glencore for invoking a provision in a contract that allows a particular party not to endure hardship? If, let me put it to you like this, Mr. Chairman, let's assume that there was no Eskom contract and the mine was enduring hardship. What would happen is the mine would close down. There's no such thing as that the company can't go into business rescue or liquidation if a company doesn't make money. That can happen. In the situation of having an Eskom contract, we really pushed as hard as we could to try and come up with a solution on a win-win basis to ensure that the mine could continue and that the power station could continue.
Yeah.
I need to go back and reiterate. If you look with hindsight, look at the mine today, look at the power station today. There's nothing there.
You see.
So I hate using hindsight, but it is what it is. But we came in, we knew there was a risk. When I say we knew there was a risk, we knew there was a risk in not doing a full due diligence. Glencore's purchased mines before without doing such an intrinsic due diligence, but that was one of the things that we had to accept. When we came in and we saw that there was a hardship provision, we invoked it. And all we did was try and protect the rights of ourselves and our fellow shareholders.
Well, one, at this stage, I have not taken a view necessarily to the effect that Glencore OCM was wrong to invoke the business rescue process. And it may well be that it's not for me to say it was right or wrong. Certainly, there seems to be nobody who says it was in breach of the agreement for Glencore OCM to invoke the business rescue route. And as I understand it, the agreement did not preclude Glencore from doing so. I've mentioned this, and I think you have responded, but I just say it again for the sake of completeness. Within the context of this matter, the Eskom senior executives, Brian Molefe and Mr. Koko, as I understand them, are simply saying we must not be blamed for our decisions not to agree to OCM and Glencore's demand or request or proposal for an increase in the coal price because of the hardship that Glencore says they were going through, because that hardship and that situation was a consequence, maybe in whole or maybe in part, that flowed from their decision, their election to take over OCM and OCH without having done proper due diligence. Because if they had done that proper due diligence, either they would have known that there was a reasonable likelihood or possibility of challenges because of this price, and maybe they would not be able to use the hardship clause to get the relief they want, and they would have stayed away or negotiated something that would have avoided this situation. So the country and the world mustn't blame us for the decisions we took and for the approach we took. That I think is in part at least what they are saying, and I'm putting it in my own words. But I think you have responded, but in case you want to add anything, I give you a chance.
Yes, I would agree with your analogy. They had their view for whatever reason, that they did not want to agree to an increase in the price, and they felt that they needed to protect Eskom. I think what needs to happen is you need to look at the sequence of events post business rescue, and you need to look at the full picture.
Yes, thank
in
you.
order to make a conclusion. This is chapter 1.
Yeah.
There is a continuation of the story.
Yes. No,
But
thank you.
it's not for me. It's not for me to go through that. You have substantial evidence in front of you.
Yeah. No,
This is just where we got to. This was, in our view, this was a transaction, not a very good one, but it was a transaction in the ordinary course of business.
Yes. Thank you. I just wanted to make sure that you have had a chance to deal head on with what I understand them to be saying. Mr. Selega, continue.
Thank you. Thank you. Mr. Ephron, you have mentioned repeatedly that the parties needed to deal with each other fairly. Do you think you were not treated fairly as Glencore OCM?
Everyone can have their view, Advocate Seleki. You know, I don't think it was reasonable in the way in which Eskom dealt with us, but you know, that was their view. That was the way that they felt that they should deal with the matter.
Yeah.
I think in hindsight it's proven to be wrong. But that being said, you know, it was what it was. We dealt with it as best as we could. I can assure you, with the utmost bona fides at all times.
Yes. Look, we have specifically been looking at the state capture features of the transaction or whatever we are investigating. And I want to ask you the question, whether do you think there was an ulterior motive in the way in which Glencore OCM was treated by Eskom, the new executive at Eskom? Whether then or now...
I can't answer that. I can't answer that, Advocate Seleki. I can only hope that you guys have sufficient evidence in order to be able to do that, but it's not my position to answer that.
Well, let's look at what happens, and maybe you can tell the chairperson what seems to be a turnaround in Glencore's decision from the 3rd of September 2015. When you were called to a meeting to meet with Mr. Koko and Mr. Brown Molefe. You recall that?
Where are you looking? Can you refer me to a paragraph?
Paragraph 50 of your statement. Page
50.
Yes, page 13, 1-3.
Okay. What's your question?
Yeah. Well, I want you to explain to the chairperson what is happening from this date onwards, because there seems to be a turnaround or a turning point in Glencore's decision regarding OCM. And we see this in this meeting of the 3rd of September 2015, where you are at Eskom, There would also be a meeting on the 24th of November 2015, and what you ultimately convey to Eskom as Glencore's decision to taking OCM out of business rescue. Are these events, and you can go into the details of those meetings for the chairperson's information, do they signify a turning point in Glencore OCM's position or not?
No, I think what you've highlighted, Advocate Seleke, is that at all times post the business rescue declaration, Glencore was funding the company to continue to produce coal and to sustain itself. We were hopeful at this point. It was under the leadership and under the curatorship of the business rescue practitioners were in control. So they were dealing with most of these issues, but the hope was that somehow a deal could be ironed out between the business rescue practitioners and Eskom. In fact, there are various overtures by the business rescue practitioners towards Eskom in order to try and see if there is a way forward. The meeting of I think it was, I'm trying to find that final date. There were a lot of circumstances, and there were a lot of facts between the time of the Glencore's decision to take it out of business rescue in, when did you say, was 24th of November?
Yes.
That's all, no, not 24th of November, sorry. I can't seem to find where you mention
the 3rd of September.
Trying to find the yeah, so it's jumping. Is it September? Yes, because it was jumping around quite significantly, and there are a lot of facts that in between. So I want to try and respond to the second meeting that you indicated. Can you direct me to a paragraph, please?
The 24th is paragraph 72. I think, let's see.
No, that was a meeting with the DMR.
Yes, no, 72, 73, start on page 18, page 19.
Yeah, so that all deals with the Oak Bay offer, and that Oak Bay were undergoing due diligence, and Oak Bay were looking at the mine, and the business rescue practitioners and a representative of Glencore met. I wasn't at that meeting on the 24th of November, but there was a meeting there that the business rescue practitioners were taking up with Eskom with regards to Oak Bay.
Mr. Ephron, which paragraph are you at?
73.
It says, paragraph 73 reads, the meeting was called with Eskom on 24 November 2015 in order to update them regarding the discussions with Oak Bay. Is that the one?
That's the exact one.
Yes, in that meeting, a number of things were discussed, but one other thing which I thought you would deal with for the purposes of informing the chairperson, where Mr. Blackfield advised the meeting that Oak Bay was conducting a due diligence and that funding has been secured for OCM for the duration of Oak Bay's due diligence period. Okay,
Yes.
let me paint a picture to you so that you can understand what I'm trying to ask you.
Sure.
So we have looked at a phase which you say is chapter 1. And now OCM is in business rescue. But decisions after it has gone into business rescue, particularly from September 2015, there's a decision to continue supplying coal to Eskom. And with that, there was a decision by Glencore to fund OCM and ultimately to take it out of business rescue. That decision was communicated in this meeting of the 24th of November 2015. And you also speak about communicating it on the 29th of November 2015. And then there's also a meeting on the 1st of December 2015 where you are at Eskom and you again communicate the decision of Glencore to fund OCM and take it out of business rescue. You recall that?
Right. Yes. So now you have the timing slightly wrong. So the 24th of November, that was not a meeting to indicate to Eskom that we are taking it out of business rescue. The 24th of November 2015 meeting was specifically with Oak Bay, the business rescue practitioners, Eskom and Mr. Blankfield as a representative of Glencore at the time, and it was all about Oak Bay's indicated desire to purchase OCM. It wasn't about taking it out of business rescue. The idea was that if Oak Bay was successful in buying OCM, then it would be taken out of business rescue. When you speak about funding was in place from the time of business rescue. We need to reiterate that if funding wasn't in place after business rescue, then immediately the mine would be in liquidation. So funding was in place from the moment business rescue started all the way through until effectively Oak Bay took control of the mine, which was sometime early in 2016. So this first meeting has got nothing to do with Glencore wanting to take it out of business rescue. On the 29th of November, however, which is now paragraph 89, that's a different story. By that time, which is a few days later, a lot of things were moving in between. I'd like to maybe read it to you.
Yes. Yeah, do so.
It's, I've just got to call up the page number, but I think you've got paragraph 89 in front of you.
It's page 22.
Page 22, apologies. On the 29th of November 2015, after Glencore OCH had declined the third Oak Bay offer and had received Section 54 notices, the Glencore team held a telephonic conference to consider its options regarding OCM, which at that stage consisted of letting the BRPs put the mine into liquidation, i.e. by withdrawing the funding being provided by Glencore, or committing to provide further funding to keep the mine operational so that the BRPs could take it out of business rescue. And I'm reading further. Paragraph 90. Glencore's decision was in part informed by its analysis of the optimum business, which indicated that the additional cost of continuing to fund and operate OCM over its remaining life of mine life compared to the third Oak Bay offer of approximately 1.1 billion, which included a number of risky and uncertain assumptions, would have resulted in that amount increasing. However, 91, despite the high cost of continuing to fund OCM, Glencore decided that the collateral damage of putting OCM into liquidation, for example, the impact on the mine's employees and Glencore's other businesses, would have been too great. We therefore decided to provide further funding commitments to allow the BRPs to terminate the business rescue proceedings, following which OCM would have continued operating the mine in the ordinary course of business. So there was a whole lot of stuff that happened before that that got us to the point where we said, okay, we've really got no choice. We have to take it out of business rescue. And that didn't last very long, because the next day, if you continue reading, a deal was entered into with Oak Bay.
Mr. Silega, of course, Mr. Ephron has previously given evidence, and today the purpose is just for him to respond to what certain witnesses have said about Glencore, Eskom, and him, and to clarify whatever else we wish to be clarified.
Correct.
Against that background, I want to ask you whether you are pacing yourself to finish by 1 o'clock.
Before then.
Okay.
Before
right.
lunch.
Yeah, okay.
Yeah.
In doing so, I do want you to take him to the clause that, or clauses that Mr. Koko referred to. Part of that he may have dealt with already, but just want to make sure I understand his answer in relation to the exclusion of the foreign market.
Yes.
So, yeah. So at some stage before you finish, you would need to do that. Yeah. Okay. Continue.
Yes. So, Mr. Ephron, can you explain this? So this is a decision where Glencore seeks or decides to take OCM out of business rescue and to comply with the
Correct.
The coal supply agreement.
Correct.
At a price of 150 rand per ton.
Correct.
When Mr. Koko was here, he drew the chairperson's attention to the minutes of a meeting where the team that was negotiating with you, the team of Eskom negotiating with you, was coming back to the BTC, the Board Tender Committee, with a report that they have negotiated with you and you have offered OCM an amount of, I think it was 268 rand per ton to continue supplying to Eskom. And he said that they were prepared as the BTC to counter offer on that and give you OCM 296 rand per ton. But then the team that was negotiating, instead of concluding the agreement with you to increase the price of coal to 296, meaning higher than what you even had offered, they decided to invoke experts to determine your financial position, OCM's financial position. Do you have any recollection of that offer you had made to Eskom?
No, there's no such offer and there's no such counter offer. I don't know. I have no idea what you're talking about. So the last offer we made to Eskom was paragraph 1 second. On the 30th of June 2015, paragraph 38. That was the final proposal. We never received a counter proposal from Eskom, but remember before this date, the 30th of June, we already had negotiated prices and under the cooperation agreement, and we had already negotiated the terms of a fourth addendum, which was never signed. But we still made a further reduction on the 30th of June, the final proposal, which is under CE8, we don't have to go to it, but it was 300 Rand per ton. We never received a response to this offer. So I really do not know about any counter proposal or any proposal ever made to Glencore or to OCM.
Okay. Chair, I can go to this clause now in the agreement. Mr. Ephron, please turn to page 71. On page 71, it's somewhere in the middle of the CSA, and specifically dealing with clause 27, which is the hardship clause. I have referred you to what has been excluded by this, which is relying on the export market. I think in your, are you there? Page 71.
Yes, I'm here.
Paragraph 27.
Yeah, what clause number?
27.
27. Okay,
Yes.
I got it.
So 27.1, I think you reproduced it in your statement. But I want to refer you to the next page. This is a clause dealing with the invocation of hardship. In entering into this agreement, clause 27.1, in entering into this agreement, the parties declare it to be their intention that this agreement shall operate between them with fairness and without undue hardship to any party. The next page, clause 27.2, the provisions of this clause shall apply where any new situation or circumstances arise, bracket relevant circumstances which, and then they give you those circumstances, but below clause 27.2.3, it reads, relevant circumstances may include, without limitation, the imposition of any tax, duty, or other fee by any governmental or other authority with executive power. Then is this part, but shall not include any circumstances resulting in TNC being unable to sell coal in the export market. You see that part?
Sure.
Yes. I've already asked you, well, by putting a version to you, that you couldn't rely on that reason or ground to invoke the hardship clause. That is, you know, your inability to sell coal to the export market.
Yes, maybe let's put it this way. What was said here by either Mr. Brian Leffer or Mr. Koko, both, is that your so-called hardship that, or OCM's or Glencore's so-called hardship that it was complaining about, was brought about largely, if not exclusively, by the fact that you were no longer selling coal to the export market. That's why you were going through these financial challenges. And that was a circumstance which fell outside of the hardship clause of the ambit of the hardship clause. So, if you went to arbitration and that point was raised, the arbitrator would have been bound to say, but I don't have jurisdiction to, I'm now putting this in my own words as I understood what they were seeking to say, to arbitrate or come to your rescue, because this has come about because of a circumstance which falls outside the ambit of clause 27. I think you did answer it earlier on, but I just want to make sure that you answer it with an understanding of the wording of the clause that Mr. Koko relied on.
Sure, if I can answer, I mean, we obviously looked at this extensively. So just to be clear, when hardship was invoked, the mine was in full production. So hardship was being incurred by the mine long before a decision was taken to cut the exports. The only reason why exports were cut, which was done from a process was started in January 2015 and ended in July 2015, was to reduce the losses that Eskom or that Optimum was incurring during that time. So when you read the clause, it shall not include circumstances resulting in TNC at the time. Obviously, Optimum being unable to sell coal in the export market, that did not apply because we were selling coal in the export market. And this is not the reason why we declared hardship. We declared hardship on the basis that there were factors that had changed in the market that resulted in the price escalation factor not being representative of true mining inflation. So I'm not sure where the allegation is coming from.
So are you saying that OCM/Glencore continued to sell coal to the export market right up to the end?
So the hardship was invoked after obviously a long process of understanding the mine. Hardship was invoked in July 2013. The mine was in absolute full production. 50% of the coal was going to export, 50% of the coal was going to Eskom. Exports only ceased in July 2015, and that was only a mechanism to reduce the financial exposure that was being incurred on the mine. Because after this point, actually the losses were slightly less. They weren't palatable, but they were less than what they were. But that's what we did 2 years later. So at the time of hardship and
in other words, are you saying there was a time when OCM/Glencore ceased selling coal to the export market, and that was in July 2015?
Yeah, it was 2 years.
Yeah.
2 years after hardship was invoked. Yeah.
But I guess part of what you are saying is you invoked the hardship clause long before that. That is in 2013. At that stage.
Long before that, with correct, and with reasons that had nothing to do with the export market. It was with reasons regarding specifically and identifiably for the Eskom coal.
Yes. Now, when you ceased to sell coal to the export market, would that have been after the termination of the cooperation agreement or before? Can you recall?
1 second. It would have been before.
Okay.
During that time, actually. During that time, the cooperation agreement was cancelled on the 22nd of June. So we were going through at that time, We
Yeah.
were going through a process.
Okay, all right. Let me ask this question, and that goes to still the issue of arbitration. Did Eskom do anything to obstruct your or OCM's and Glencore's process to take arbitration to finality? Is there anything you are saying Eskom did to prevent or unduly delay the your journey to final arbitration on this hardship issue?
No, I don't. I think they, in the normal course, it's not advantageous to them to have a hearing immediately. So the longer you can wait to have a hearing, the better off they are, because you don't do anything until the hearing is held. So when we tried to get meetings, and when we sent them a hardship letter, they immediately sent back that the hardship letter wasn't sent correctly. So they tried whatever they could to delay, but that's normal litigation, I guess. I don't think necessarily there were any malefides at the time. It was just, one party reacting to another party's overture to say that we have hardship.
Okay, all right. Mr. Selega?
Thank you, Chair. So that's the clause. I think you've answered, Mr. Ephron. Mr. Ephron, please turn to page, just to confirm that this is your letter invoking hardship, page 328. Is that 328? Yes. That will be...
Yes, this looks like it. Yes.
Is that... So it starts on page...
Yeah, for some reason I thought it was the 13th of July, but I see it's the 3rd of July.
Well, this is a 2013 one.
Yes.
That's correct. So I thought it was. I had it in my papers as the 13th of July, but that's wrong. It's the 3rd. It's the 3rd of July. This is correct. This is the document.
Were you not talking about July 2015 when you said that?
No. This is Advocate Seleki asked me about this letter if it was the 3rd of July 2013. This is the letter.
Yeah.
This is the exact letter we sent to Eskom.
Okay, all right.
So this is when you invoked the hardship clause.
Correct. And as you can see, it's an extensive letter.
Yes. And you are saying in this letter, well, at this stage, in July 2013, OCM was still providing coal to the export market.
Absolutely.
And it was only in July...
It was in full production.
Full production. And it was in June, July 2015 that you closed the export component of the mine.
Correct.
So I think that, well, there's one more question, but I don't see. The documents here. I'm going to have to refer you to a different...
While you are doing that, let me ask him a question while you are looking at that. You said in your initial or first statement, Mr. Ephron, that as I understand it, you said that Glencore took over OCH and OCM when they didn't understand the price adjustment mechanisms of the coal supply agreement. Did you get to understand how that price adjustment mechanism worked subsequently, or is the position that you never understood how they worked? I'm just asking because you didn't invoke them, so.
No. We immediately understood it as soon as we came in. It took about a year to really get to the bottom of it, but I know that you don't have the time, but if you read if you read the hardship notice.
Yes, hang on.
If you read the hardship notice that.
Hang on. We do have the time to hear fully what you want to say in response to what has been said.
Okay.
So, but I was referring to the fact that there is an extensive hardship notice document which Advocate Seleki just referred to on page 328. It's a 8 or 10 page document. We can go to whatever document you want to ask to go to.
This letter, the hardship invocation letter, goes into extensive detail of the hardship reasons and the price mechanism in the contract.
What page
It's
is that letter?
Extensive.
Is it this one?
Page 330. Page 3. 1 second. 330 starts on page 332. 330.
Or the letter that we were looking at just now.
Yes, that exact letter. 328. 328.
Yes. Okay.
If you browse through that letter, you'll see.
Yeah.
It goes through. It's an extensive letter. It goes through all the details around hardship, why hardship, what's happening with the escalation of prices, why the prices have done what they've done, what's happened to the costs on the mines.
Yes.
It's got everything.
Yes.
It's got everything. It talks about how it's calculated. It's got the graphs. It's got the PPI adjustment. It's an extensive document.
Yes. So I guess the point you are making is that a reading of that letter will demonstrate that you got to a stage where you understood how these mechanisms, price adjustment mechanisms under the contract worked, but you took a certain view of their utility. Is that correct?
Correct.
Okay, all right. Mr. Selega.
Thank you, Chair. This is going to lead me to a completely different aspect, and I'll conclude with that. It deals with the penalties, Mr. Ephron. Because there was an issue about Eskom allegedly failing to notify OCM as and when they provided coal that was non-compliant. And that as a result, allegedly, of that failure, Eskom could not pursue certain amounts of penalties against OCM. But when Mr. Koko was here, he drew the chairperson's attention to a clause in the agreement. I'll refer firstly to that one, which is on page 49, clause 9.6. which imposes an obligation on the part of Eskom to give monthly notices. Let me know.
Okay.
Let me know when you're there.
I'm here.
Is there?
Now, this clause requires Eskom, well, let's see.
I'm sorry, you are at page 49,
49, Chair,
paragraph or clause?
9.6.
Okay,
Yes.
right.
Which reads, unless TNC is notified in writing to the contrary within 15 days after each day's delivery of coal, such coal shall be deemed to conform in all respects to the specifications, and Eskom shall have no claim whatsoever in regard thereto or arising therefrom. Such notification shall specify full details relating to the delivery of coal concerned, including the date of delivery, the quantity of coal concerned, and full details of the non-conformity of such coal to the specifications. Were you familiar with this clause?
I'm not if I'm familiar with that particular clause, but I'll take it as read.
Now, then there is a settlement agreement which became addendum, the second addendum to the CSA.
Maybe before you go there, Mr. Selega, can I ask this question? Do you know, Mr. Ephron, whether Eskom did usually and regularly comply with this requirement during the period, let us say from 2012 right up to 2015 or up to the business rescue time, namely when you had delivered coal every day, did they regularly send notices to indicate that the coal did not comply with the specifications or with the quality or the quantity? Or is that something you don't remember?
It's quite a long time ago, but I do recall that there were reasonably regular letters, and that they didn't necessarily refer to all the qualities. They only may have referred to sizing, if I recall. So
Yes.
I can't seem to recall exactly whether every month, but what was happening was normally if there was some penalties, there was a set off would apply in most instances, and then specifically the one that caused most of the problems was the sizing, and that's where the whole thing went a bit wayward, because if you 1% out on the sizing, then Eskom's entitled to reject it, and whether they should have rejected it at the time without burning it or not, we don't know, and that would have been an assessment for the arbitrator or in some sort of legal form. I can't seem to recall exactly.
Okay, all right, Mr. Selega.
Thank you, Chair. So that is the position in regard to clause 9.6. But then there's a settlement of arbitration which starts on page 303. Mr. Ephron.
One sec.
Settlement of arbitration and second addendum to the Hendrina coal supply agreement. I see that.
I've got it.
Yes. Thank you. I see that this settlement agreement on page 317 and 318 was concluded on the 12th of April 2011. Between Eskom, Optimum Coal Holding, and Optimum Coal Mine.
I'm with you.
So this would have been before the acquisition by Glencore.
Correct.
But you would have taken over this, the CSA with this addenda to it.
Correct.
Now let's go to page 311. Clause 3.4.2. And this is under the heading Quality of Coal, clause 3.4, which starts on page 310. So 3.4.2 says the parties specifically agree and record that the spreadsheet in respect of the qualities of coal sold and delivered by Optimum Colliery to Eskom, exchanged between the parties on a daily basis, will constitute ongoing compliance with the provisions of clause 9.6 of the CSA. You follow that provision?
I do.
Yeah. Now, the explanation by the witness, Mr. Koko, was that this essentially, if not in fact, maybe in fact, changes or varies the position in clause 9.6 in that, and I will add this from my side, that you no longer require to give a notice as envisaged in 9.6, but that the spreadsheet here envisaged, an exchange on a daily basis, will constitute compliance with 9.6. In which event, if the spreadsheet is exchanged, and you will tell us whether or not it was, that means there is full compliance with 9.6, and Eskom, if failing to give you notice as originally envisaged in 9.6, cannot be said to have waived the right to impose the penalty or to claim the penalty.
You understand that proposition?
Okay. Yeah, I'm just not sure where you're going on this exactly.
What
are you trying to get out of me?
Let me put the question this way, Mr. Ephron. Mr. Koko said, based on this clause 3.4.2, the position was that after this settlement agreement relating to arbitration, the position was that Eskom was no longer required to give OCM or Glencore notice within 15 days that your coal was defective in this way or that way, whether it's quantity or quality. All that was required was the exchange of this spreadsheet. And therefore, to the extent that anybody may have thought that you could have said to them when they put up their claim for 2 billion rand penalties, to the extent that anybody may have thought you could say, but where are your notices that you served on us in terms of clause 9.6? Because if there are no such notices, then your claim must fail. You have no claim against us. He was saying that kind of argument was no longer available after the conclusion of this settlement agreement because of clause 3.4.2. All that was required was to show that that spreadsheet was exchanged. Do you have something to say to that?
Right. Yeah. So I don't think we ever disputed that. So I'm not sure.
Yeah.
I'm not sure on what grounds it's being discussed. So we never disputed that. We believed that we had plenty of grounds in terms of the penalty calculations to dispute the penalties, but I don't recall disputing penalties on the basis of no notices given.
Yeah, okay, no, that's fine.
In fact, we never got it. We never got into a formal dispute on the notice, on the penalties. We were always, the first time a dispute arrived was when we got the demand letter.
Yeah. In 2015.
In July 2015, but it was never a dispute. It was always under discussion because Eskom on site all the time, so they knew what was happening every day. So it was never a dispute on penalties. It was always a disagreement, but it was never a formal dispute. So I'm not sure where that comes from.
Okay, no, that's fine. Mr. Siliga.
Okay, so the disagreements you are saying, Mr. Ephron, to the chairperson, were on different grounds, and not this particular, not this particular ground.
Correct.
Yes, that's what he's saying. Yeah.
No, I don't recall, but I do not recall.
Okay. Chairperson, that brings me to the end of my questions.
Yeah. Just before we finish, Mr. Ephron, just to sum up, and I know that you said that this is dealt with, I think, in the letter that we looked at earlier on. Why was the price adjustment mechanism in the CSA not invoked by OCM stroke Glencore? You want to just, in summary, just deal with that? Or is it, or tell me?
Mr. Chairperson, can you repeat the question? I didn't.
Yes.
You broke up a little bit.
Yes, maybe let me start by saying, am I correct in understanding that OCM stroke Glencore did not invoke the price adjustment mechanism provided for in the CSA to deal with its challenges about the price?
That was the basis of the hardship. The mechanism in the contract on an annual basis was the basis for the hardship, because every year the contract was being increased by a lower amount than mining inflation. So if mining inflation was 10% in one year, the contract would only go up 8%. And in the following year, the same. And it was every year, the gap between costs and selling price was diminishing because of this adjustment mechanism. And that letter that I referred you to down on page 328 goes into all the details around that.
Yeah. So
had that mechanism been reflective of mining inflation, there would have been no hardship.
Okay, so in
other words, simplistically.
In other words, are you saying the price adjustment mechanism in the coal supply agreement may have been a good idea to deal with the issue of increasing the price from time to time, but the problem with this price adjustment mechanism is that it was based on increasing the price according to the inflation rate, but the costs that OCM and Glencore were incurring required that the price be adjusted by more than that. Is that what in sum you are saying?
Yes, but not specific to OCM's costs.
Yes.
Specific to industry inflation.
Okay,
It's not OCM's costs that were relevant. One
Yes.
looks at, like, the other adjustment mechanism factors in the other Eskom contracts are basis what's happening to the fuel price, what's happening to the cost of salaries and wages, what's happening to the cost of mining equipment. And the mechanism in the optimum contract was not reflective of what's happening in the market,
Yeah.
not what's happening at optimum.
yes. So in other words, are you saying it had become unrealistic over the years or at the particular time, this mechanism?
Exactly.
Yeah,
Over the years, exactly.
okay, all right. Okay, is there anything else you wanted to say before we adjourn? You are done.
No, thank you. All good.
All right.
I'm done.
Yeah.
Thank you so much.
Thank you very much, Mr. Ephron, for coming back to deal with these matters. We are now going to release you because we have dealt with the questions that needed to be dealt with. We are going to adjourn for the day. And then in terms of the public, as things stand, the commission will not sit tomorrow. If that changes in the course of the afternoon, the public will be informed. Otherwise, the next hearing will be on Tuesday, not in the morning, but in the afternoon at 4 o'clock, when I will hear various applications for leave to cross-examine that have been brought by various parties whose applications have not yet been decided. After that, then the hearings will continue on Thursday and Friday next week, and beyond that, we adjourn.